begin by giving a brief overview of the current state of affairs regarding SEP and transactional aspects. We have the benefit with this panel of, I'm as moderator from North America, US. We also have a great wealth of knowledge here on Asia and India in particular. And then with Stefan, we have a European perspective. So I think we can provide a nice summary of the current status of things globally for you. And then we just identifying the issues at that point. That's number one. And then number two, we'll drill down on specific issues because, as you know, I'm sure many of you are aware, this SEP FRAND issue is gigantic in the global marketplace right now, and the many, many issues that surround this. So I'm going to start with this brief overview, number one. And I will ask Stefan if you wouldn't mind to start off with some discussion of current trends in Europe generally, and then we'll turn to India, and then I'll give a wrap-up of US before we move to a drill down. Stefan?
Well, thank you, Patrick, for the introduction. As you may know, Europe and especially Germany was one of the epicenters of the smartphone wars, and probably still is. And inevitably, the issue of standard essential patents and FRAND came up in litigation. Why is this? Because we have case law that in a nutshell says if you are controlling standard by patent and thereby this you have a market dominant position, the user of the technology, or in this case the defendant, has a right to a license, not a free license but a license to FRAND conditions. That was established probably 5 or 6 years ago, but then the question is, well, obviously not everybody should be a free rider on technology, and there were basically two positions. One was the German courts that said, well, if you are the defendant, if you are the evil infringer, so to speak, and exceptionally we let you off the hook by not granting an injunction, you really have to behave like a proper licensee, so you have to make a FRAND offer, you have to abide to all provisions of the contract, even in anticipation of the conclusion of the contract. And that, of course, was a great burden, and guess what happened? Defendant said, my offer is FRAND. The patentee said, well, your offer is not FRAND. The court stood in the middle and said, well, we don't know, but the defendant hasn't made its case, and hence we can't injunction. So that never worked. The counterpart was the EU Commission, which in a procedure against Samsung took the position, well, it's just sufficient to be a willing licensee to avoid an injunction, and that was rightly criticized as it gives rise to what is called reverse hold-up. You pretend you're willing, but you track out negotiations, and ultimately, and so that the patent cannot be enforced against you, and that could not be right either. The thing went up to the ECJ to get up to the latest, to get to the latest developments. The ECJ ruled in its wisdom some middle ground. Basically, there are 3 criteria. First, the patentee has to give notice of the infringement. Second, the patentee has to start the licensing process by making a FRAND offer, and to which then the defendant has to reply either by accepting it or making a counter offer, which again should be FRAND. The court ruled also, which was disputed before, that in litigation you can challenge the validity of the patent, and you can also challenge that you're using the patent at all, which some German courts held before was not allowable. And then there was a proviso with the whole decision that all this only applies if indeed the standard grants a market dominant position. People said this is a nice decision, it takes some middle ground. The problem is, of course, how to apply it as usual when we get something handed down from the ECJ. And there were three conclusions drawn, maybe more, from this decision. The one was, okay, the ECJ only talked about dominant position, so the courts will first assess, is FRAND an issue at all? If the standard does not establish a dominant position, we don't even have a case and we grant our injunction. So that's the easy thing. And there are standards that don't establish a dominant position because there are alternative technologies that are accepted in the market, or the standard has not been established to that extent that it establishes dominant position. The more interesting thing is, well, what about the notice to the infringer? And there are two schools of thought. The one school says, well, this actually means that has to be pre-litigation. Because the idea is, and that has some reason to it, things should be like in a normal negotiation. And if you only make your negotiations while litigation is pending, that's of course under pressure for the defendant to conclude a licensing agreement, because the clock is ticking, and after 15 months there will be an injunction. By then you have either concluded the agreement or you will get the injunction, and of course the longer the clock is ticking, the better the position of the patentee, and at the end maybe even the patentee may drag out the negotiations and just wait for the injunction to come. The other school says, no, a complaint is sufficient notice. That's one thing. That has to be sorted out. Another thing, and that's more interesting, is what about this FRAND offer by the patentee? And so far the patentee came, okay, our standard license is this and that, and our standard royalty is $1 per piece, and please accept this. Well, it was of course more detailed, but that was the information why they gave, and the courts came now and said, well, we cannot determine what is a FRAND royalty, and we don't want to do that. That's for the parties to negotiate. However, what we can do is check whether the offer is FRAND under legal terms, that it is fair, reasonable, non-discriminatory, especially non-discriminatory. And to this end, the patentee really has to set out why the offer is FRAND. And that we had a preliminary communication by a court in a pending procedure, which basically said, okay, you have to communicate. If you rely on other licensing agreements, you have to present them to the court, given the case under the secrecy order. You have to explain why these are comparable. You have to make provisions in case the patent coverage shifts. So basically you have to explain your patent policy to the court. That was one thing. In another case, the court simply said, it's not enough if you just say, okay, we grant you a license at a royalty of X per piece. You really have to explain why it's FRAND. So if I were to look into the crystal ball, and these are all first instance decisions or pending procedures, and we don't have any ruling from a high court, but if I were to look into my crystal ball, we might have a dispute to what extent the patentee has to explain its patent policy to the court if it wants to get an injunction, which may lead to a situation that seeking an injunction may not be so attractive anymore, because you may either not be able to convince the court, or you have to disclose certain things you don't want to disclose. So that's where we currently stand. Nutshell is injunctions are granted, whereas until ECJ decision they were granted as a matter of course, more or less, because there was always a dispute about the royalty. There could be a tendency now that it will be more difficult for the courts, and certainly for the patentees to get an injunction, and certainly the courts will require more from the patentee, more explanation, and possibly also from the defendant in its behavior than was before. Now, there is, on the other hand, the good news, there is the prerequisite for all this is that the defendant is a willing licensee. And if you have an unwilling licensee that drags out negotiations, makes unreasonable offers or whatever, then again the courts have been, even post ZTE Huawei, been very adamant to cut it down, grant the injunction. Okay, I'm over the time, I know. Okay. Thank you.
Okay. We're trying to give just an overview of what the current trend is at a high level. I think that's very interesting that the issues there in Europe, the injunction is certainly an important issue in the States right now, and I'll come back to that later, but it's interesting to hear in the aftermath of the ECJ's decision last year regarding injunctions that is a key issue in Europe, and I think it's an issue that India is considering and addressing, and so let me turn to Sanjeev for an overview of some of the issues here in India, and then Deepak, I'll ask you to follow on with the issues, and then we'll hear from the corporate perspective what the current state is here. So again, an overview of just what are the hot button issues in India.
Thank you, Patrick. Good morning, everyone. Thank you for panelists. So far, we have an interesting update from Stephen on the European perspective. In India, so far as we all understand, beginning from 2013, we have seen an encouraging sign for the innovators. The ACPs have been enforced. Probably we have 3 sets of cases so far. One, the Ericsson's 8 patents and the suits against 5-6 defendants. Then there was a suit by Bringo, 2-3 suits by Bringo, including their ACP action, and recently the suit or the action by Dolby based on their 5 ACPs against 5 defendants, 5 implementers. Now the learning so far from these 3 broad actions in India, that injunctions or interim injunction as such can be granted. The courts are inclined to grant even ex parte injunction. Ex parte means without hearing the implementer. There had been a criticism of these decisions, the ex parte decisions or the interim decisions. However, fact remains, based on those ex parte injunctions, party negotiated, they came out and they put their proposal. Court, based on the agreed terms, proposed the interim royalty. Those interim royalties were further modulated in view of the parties' disclosure of certain license or the terms which are applicable in the relevant area of technology. But the arrangements as of now in the cases involving Ericsson and Dolby, that the implementers whose products are accused are paying certain amount of interim royalty to the either Ericsson and Dolby. At the same time, the implementers have raised issues of anti-competition. The actions and the complaints have been filed before the Competition Commission of India. Those issues are still pending adjudication before the High Court of Delhi. The issues regarding the interplay of the Patents Act and the CCI, what role the Competition Commission can play in view of the substantive provisions of Patent Act. The writ court at the first instance, they found the 2 jurisdictions are separate and the Competition Commission can still look into, though the Patents Act provides substantial remedy and carve out also measure for anti-competitiveness. Still, the Competition Act has its own role to play in view of peculiar provisions and also the nature of remedy which is available under the Competition Act. Having said that, I can say that it is still in early days. Adjudication relating to the issues before Competition Commission of India are to be finally adjudicated by the Division Bench of Delhi High Court. It may reach to the Supreme Court. We may have some kind of certainty once we have a final verdict from that channel of the complaints coming out of the CCI. And secondly, even in the suits involving Ericsson, where the evidences are being led, the trials are underway, probably we may hope the final adjudication and the final decision by the Court of First Instance maybe in a year's time, and that could provide a proper Indian perspective. Right now what we are looking at the interim measures pending trial and final adjudication. Having said that, from the innovator's perspective, it is a good sign that the courts in a given fact situations are inclined to grant ex parte or the interim injunction, whether bad, good, indifferent, but courts have taken the approach in their own wisdom based upon the facts of the cases. And that is a good sign for the innovator companies, may not be so good for the implementer. And based on those precedents, we can certainly say that the courts in India will be inclined to grant interim injunctions, considering also the fact that the trial and the final adjudication by the Court of First Instance certainly takes time. It may take 3 to 5 years depending upon the jurisdiction in the court, but still it is a good sign, the good development beginning 2013 onward. So far, we can say that the enforcement scenario in India from the innovator points of view there is some clarity that the multinational innovator company look towards, and given the facts that India is a very huge market for the SEPs in the telecom sectors or or any other, considering the consumer base and the number of handsets, the number of networks we do have. So this is early days in my view. It may take a year or so to have some kind of genuine precedent based upon the trial. Thank you, Patrick.
Thank you, Sanjeev. And Deepak, if I could ask you for additional comment or other areas, I think that's a great summary of the ex parte injunction status here in India, which is something very peculiar to us in North America. We have difficulty in the States of even granting injunctions post-decision. So,
yeah.
Deepak?
The grant of interim injunctions have to be viewed especially from the Indian side, meaning thereby that the time being taken by the Indian courts to dispose of an entire trial. And if you look at that, and as Sanjeev said, it can take anywhere between, at the first instance, anywhere between 3 to 5 years. The interim state is nothing to do with the legality. It has to do with the balance of convenience and the equity side of it. And when we look at the equity, the principle is that both parties should not gain out of the pendency of the litigation. Neither party should gain out of the pendency of the litigation is what the primary part would be. On one side, we have the innovator who already has agreed to grant the license on a FRAND term as opposed to demanding anything of his choice. That's an upfront commitment which has been made by him. So what is left out is that he is unable to, retract back from that and demand for a license fee which can be beyond a FRAND licensing condition. So there comes a, equity or reasonableness from the patentee side, and the other party which has to be a defendant, he cannot be allowed to piggyback and, hold the cost of the due royalties. Unless there is a huge and credible challenge which is prima facie visible on to the patentability of it, validity, there has to be a really huge credible challenge. Not to the extent of normal credible challenge as what we will take up in the normal litigation, not involving a FRAND patent, because it's a SEP patent, so there is a declaration to the extent of standardization, essentiality side of it. People may say that the essentiality has not been validated, That's a different issue altogether. But there is a commitment. That essentiality is being committed by at least a party who is filed the application, and he is not bluffing it off to a very large extent, There is no need for him to bluff. Because if he bluffs it off, then he is, probably inviting a gelatin onto himself to subject the royalties to a FRAND basis. Let's look at Apple versus Samsung case and this entire scenario. Samsung litigated in USA on the basis of all standard essential patents, and it was not very favorable for Samsung when it came to the royalty rates. On the other hand, when Apple litigated using non-essential patents, the royalty rates which it was able to demand and get from Samsung was really big compared to what Samsung got offered. Despite the fact that they were infringing, Apple was found to be infringing SEPs, and the other way around, Apple was found to be infringing SEPs and Samsung was not found to be infringing SEP but simple patents, non-essential patent. Despite this, the royalty rate when it got determined, the royalty was to be paid in effect by Samsung to Apple. So that is one of the bigger things that we have to be considering on the grant of interim stay. And if we consider that as a prima facie portion, and other issues such as willingness of the defendant to sit down and negotiate in good faith as to what should be the royalty rates which are applicable, what he is ready to give, all those parameters have to be taken into consideration. Many times the court, especially when we look at the litigation which have gone through, some of the places the willingness of the defendant to constructively negotiate has been found to be lacking there. So, in light of those circumstances, the court has till now proceeded to grant interim injunctions. But assume as a reversible scenario where the defendant is actually more than willing to negotiate the FRAND license, the court may be not so inclined to grant interim injunction. So it's a very fact-specific precedent which has proceeded till now. I will not generalize it and say that interim injunctions are grantable in every condition of FRAND. And also the courts have been more than happy to vacate the interim injunction within a very short period of time. For example, the interim injunctions have actually served a very huge purpose of bringing the defendant to the court, which otherwise may not have happened at all. They may have taken their own sweet time to sit down and come to the court and start the negotiating process, unless until there was some sort of business need, humongous business need. And that's not a legalistic issue, it's a human business need. If you are being forced as a company to shut down your operations, then you would at least show the willingness to enter into some sort of negotiation properly. So the court is aware of that fact also. And that is what the interim injunctions have actually served. Bring them to the negotiating table ASAP. And subsequently thereof, they have vacated. In all the cases, subsequent to the defendant coming to the court and admitting to the extent of interim royalty rate, the court has vacated all the interim injunctions and has allowed the products to be sold so that the public at large is not also being affected. The interest of the patentee in all these cases is not to stop the product from coming into the market, because if that actually gets stopped, the FRAND itself in totality will get the percentage of royalty which will otherwise come to them will stop. So it's not in the interest of the patentee to get an injunction. It is actually in the interest of the patentee that the products are being sold. So in all those cases, even the patentee has not taken a stand that the injunction should be continued. All that they have taken a stand is, let the party give some sort of interim settlement agreement, enter into interim settlement agreement, let them continue in the market, and subsequently whenever the final adjudication happens, they will go by that. So that's the difference between the Indian and the worldwide perspectives. With that, I will stop.
That's a big difference. Having an early stage injunction, as I said, is absolutely significant, and it's a foreign concept to our American jurisprudence. But that's an interesting overview of the perspective. of what's happening in India on a general scale, and I would like Sheetal to address it, what she's seeing from the corporate perspective from Ericsson and possibly from competitors of Ericsson, who I'm sure you engage with on a fairly regular basis.
How much time do I have?
A few minutes.
Few minutes. Okay. So warm welcome to all of you here, and many thanks that you showed up. In fact, when the coffee break was there, we thought maybe whether you will turn up or not. So I'm so happy to see all of you, and you have really made us feel very elated, and you are here, and we'll do our level best to just exchange our views. I think it's extremely difficult for me to talk about India's specific thing after when both my co-panelists on India have already spoken. Whatever I wanted to say, you have already taken it away. So I'll just keep it on the top of a cover as to why what is happening in India. We are trying to sell you a story here as a panelist of a character of a story which you are all carrying either in your hands right now or in your pockets. What is it? Mobile phones. And the patent wars that are happening in India. Not only in India, I think globally this is an issue. But I think it's a mode of celebration in India because at least Ericsson had a chest and a spine to go to the court, seek relief, and bring in a larger clarity that was not there just before this case ever happened. And let me tell you, and believe me, that ever since I've seen these court cases happening, as a consumer, I've started to love my phone more often now, and I never realized, the technology that goes into it and the kind of empowerment we all have today. Well, I have now just few minutes, as Patrick just said, which is quite a challenging task to cover story of a mobile phone which has actually touched the life of 7 billion people. And a few minutes to talk about it, I think it's really less, but I'm sure we'll drill down more into it. Well, let's first see why there is a fight in India. What is actually the scenario? I think if I have to state in one statement the key challenge in India, the key challenge is there is a fight or a tug of war between emotions and a logic. Logic is that there is an essential patent owner who has invested billions of amounts